All right, I'm going to go ahead and get started. Good evening, everyone. Thanks for joining. I'm Melissa. I'm an attorney with the Monteleone Law Group. We are a multi-service firm. We handle many different things, but I handle the estate planning and elder law matters that come into the firm. And that could be a variety of things. But tonight we're going to focus on estate planning. Elder law and estate planning covers a lot of different things, but my main focus tonight are going to be some common mistakes that we see come into the office and how to avoid them, because it's important that we get this right. So before we get into our presentation, I just want to go over a couple of housekeeping things. This webinar is being recorded, and you're going to get a copy of it in your email within the next 24 hours. So that way you can listen to it again. You can share it with a friend. It's some good and important information to know. Actually, the slide is wrong. You're not going to get a copy in the slides via email. Zoom does not let me do that. But if you do want a copy of the slides, that's fine. My email address is in the presentation at the very end. You can just email us and I'll get you a copy of the slides. And I believe everyone should be muted. I don't have a moderator with me tonight. So what I'm going to do is, if you have a question that you want to ask, you can put it in the chat. And it will come through. I may not see it during the presentation, but I will look at it at the end, and I'll address any questions. And I'll also have some time at the end where we can unmute you and you can ask your questions. So everyone should have a chance to pick my brain. And before we get into our presentation, of course, I have to give you a disclaimer that the information that I'm going to share in this presentation is for informational purposes only. You should not rely on this as legal advice, and instead, you should set up a consultation and let's talk about what you have going on specifically, because there's always different ways to attack a situation. So please don't rely on this solely as legal advice. It's just for informational purposes only. Tonight's topics, we'll be talking about three things. First, I'm going to talk about generally what estate planning is. What does that mean? It could mean a lot of different things, and we'll talk about that. Then we'll go through our 10 common mistakes, and then we'll talk about how you can avoid them. So what is estate planning? An estate plan is a plan to ensure that your wishes regarding your health care and your assets are carried out. I think of estate planning like a spectrum. There are documents and decisions that need to be taken care of while you're alive, and there's a certain part of your estate plan that handles that. And then there's a whole other set of documents that deals with what happens when I pass away. And typically, your estate plan consists of your will or your power of attorney, your healthcare proxy, or a trust, HIPAA release forms. There's a lot of different documents that can make up your estate plan. And it could be different depending on what your situation is. So it's not a cookie cutter plan. It is something that's tailored to an individual based on their family, their goals, what they want for themselves and their loved ones. And anyone's estate plan should be a plan that addresses your values and your valuables. So when I refer to your values, I'm talking about decisions regarding your end of life care, how you want your money to be spent. These are important decisions that should be made while you're alive. So that way, if something happens to you, like an unexpected illness, or you're unavailable either because you're traveling and you can't get back in the country, or you've had an accident. You want to know that if something like this happens, you have peace of mind knowing that I'm protected. I have a plan where someone can step in and act on my behalf, and I know I'm going to take care of my family. So this is why estate planning is so important, particularly now when we're in this crazy world with COVID and so many people becoming ill and other unforeseeable things happening. It's really important that you have yourself covered with an estate plan. So now we will get into the 10 most common mistakes. The first one is maybe pretty obvious, failing to even have an estate plan. If you fail to plan, you're planning to fail. And it's estimated that about 40, I think it's 42% of people in the US have an estate plan. So that means that a majority of people don't have one. And only 36% of people with children have an estate plan. And kids tend to add an extra layer of complications or things to think about when it comes to an estate plan. So it's even more important that people with children have an estate plan. So it's never too late. It's never too early to have an estate plan. I have a lot of people that come to me and say, but I don't have anything. Why do I need this? It doesn't matter if you have $1 in the bank or $10 million, or if you're 25 years old or 75 years old. We don't know what tomorrow is going to bring us. We always need to make sure that we have a plan to say, if something happens to me, who's going to make my decisions? What will happen to any of the assets that I have? Maybe I want to give it to charity, or I want to take care of a family member. But we don't know that unless you have it in writing. So that's why it's important to make sure that you have an estate plan. And when you don't have one, the consequences could be severe. For many people that don't have an estate plan, they don't have a power of attorney, they don't have a healthcare proxy or a living will in place. The consequences that is a guardianship. I work with many families where mom or dad, they're getting older and they don't have any documents in place, and they're no longer to take care of themselves because maybe they had a stroke, maybe they have dementia, maybe they're just ill. Their kids or their family members can't help them because they have no documents in place. So when that happens, we need to get the courts involved and get a guardian appointed. And it can be a difficult situation if maybe family members don't agree. And it's just something that really no one should have to go through, because it could all be avoided with a simple document. The other consequence of not having an estate plan is what's called intestacy. So if you die without a will, the law will provide one for you. They will tell you how your assets are going to be distributed to what family members, and maybe that's not the plan that you would have wanted for yourself. They don't account for giving charitable gifts, or maybe taking care of your grandchildren or to other family members that may need it more than others. It doesn't account for when you have family members with special needs, or if there's credits, certain family members that maybe have issues with creditors or going through a divorce. The law does not take any of that into account when you don't have a will. So it's important, again, to make sure that you have an estate plan that fits your needs. Mistake number 2 is also failing to review and update your plan. So life happens. An estate plan is something that you don't just put it together and that's the way it's going to be for the rest of your life. It's a set of documents that grow with you, because we grow and change during life, and maybe our decisions on how we want our money or our healthcare to be handled will change. So it's important that anytime you have a major life event, a marriage, divorce, birth of a child, if a family member dies, if you have a substantial change in your health, anytime any of those big things are happening, you have to take out your estate plan and just review it and figure out and ask yourself, does this make sense anymore? Is this how I want things to be handled based on what's happening in my life right now? Because the answer may be no. And it's important to make sure that your plan reflects that. And even if you don't have any big life changes, it might make sense to take your plan out every 18 to 24 months and just look it over. I have many clients that come to me and bring me copies of wills and trusts and powers of attorney that are 30 years old, and they've had children, and their will talks about who they want to be the guardian of their infant children, and their children are grown and out of the house. Your will should have very much been updated in between then and now. So another big thing about updating your estate plan is in terms of your medical and your health decisions. Because when we're younger, we may have one attitude to the type of medical care that we want for ourselves. But as we grow and as we age, we might have a different perspective based on what kind of medical conditions we have, or that would dictate, maybe if I have a sudden illness and I'm at the end of my life, maybe I don't want to be on a ventilator. Maybe I want to just let death happen naturally and just be made comfortable. And these are all things that need to be put in writing, because many of us are not mind readers, and we don't know what someone would want unless we're told. And if it's not written down, then it never happened. So it's important to decide how you want to communicate your wishes to your family. The third mistake has to do with blended families. So many people with second marriages, a lot of times people will use a traditional estate plan for a blended family, just a simple will that doesn't take into account how to handle the special considerations, like when people come to a marriage with children. The default laws and rules are biased to traditional families. They think of a family as a husband and a wife with their children, and they don't take into consideration that people are getting married and divorced and remarried all the time, and they come to the marriage with children. And how do you take into consider splitting up our assets when maybe I came to the marriage with bank accounts and a house, and I've had this for years, and I want to share it with my children, but maybe I don't want to share it with my husband's children, or something along those lines. So it's important that if you have a second marriage or a third marriage, or if you have a blended family, that you are working with an attorney to make sure that you have an estate plan that's tailored for you, because there's a lot of special considerations that need to be made. There are separate assets that people come to their marriage with. Um, you know, is it part of your plan that you want to take care of, that the husband and wife want to take care of one another after they pass away? What would you do if, how would you handle if one of the spouses wanted to get remarried? These are all things that would have to be considered and outlined in your plan. Our fourth mistake is failing to consider the children. And I touched on this earlier, that kids add an extra layer of consideration in the estate planning mix. So one of the things is, when you have small children, it's always good to make sure that you make it known in your will that who you'd want to be the guardian of your child. If something should happen to you and you're not able to take care of your child anymore because you've passed away. So that's at the most basic level. You need to consider who would be your child's guardian if you were to pass away or even become disabled. And it's not just the who, you need to consider how you'd want them to be cared for. So if you pick one person, you need to always consider a backup, and think about, if this is the person that I want to take care of my child, what if that person got a new job in another state and they were going to move across the country? Would I still want them to be my child's guardian? Would I then think of a backup that would stay here with my child so my kid doesn't have to pick up and move to an unfamiliar place? What about if I'm picking guardians that are married? What happens if they were to get divorced? Would I still be okay with my child staying with them in that situation? So these are all things to think through. They're very big decisions, and there are things that need to be thought of carefully. but it's information that needs to be considered because life happens, and all these different situations could present themselves at the time that you're unable to speak for yourself. So you need to give guidance to your loved ones so they know how to handle these things. Um, Special considerations for when you're estate planning and dealing with kids. So a lot of my work has to do with planning for people with disabilities. And with that comes always making considerations for government entitlement benefits like Medicaid, like SSI. And sometimes when people have special needs children, they get these benefits. And if we leave children money, that could upset their benefits and could disqualify them from getting benefits. So that's why the special considerations for children with special needs need to be made. Unfortunately, there's a lot of families that deal with addiction. What do we do when we have a child or anybody in our family that has an addiction and we don't want to put money in their hand because we might be fueling their addiction? How do we deal with that? Or what about a child who maybe I don't like their spouse? It happens all the time. Or I know that there's a divorce that is bound to happen. How do we deal with that? Or what about if my kid is just really bad with money and they've made poor decisions, they have judgments against them? I don't want to put money in their hand and have someone else come and take it away because they have a judgment. These are all things that need to be taken into account when you are figuring out how to pass along your assets to your kids, because we want to leave a legacy and we want to take care of our family, but we need to be wise in how we set that up. And there's always a way to do that. We just need to do it carefully. So it's always important to consider the kids in your estate plan. Mistake number 5 we see often is failing to have a backup plan. You've gone through all the hard work, you've made a plan, you've named your executors and your powers of attorney and your agents for your healthcare proxy, but you didn't name a backup. And that could be a problem. Why is that? Because sometimes, we don't think about the what if. Like we think about we need to make a plan, but then we don't think about the alternate what if this person isn't available. So we always need to have a backup for our key players. So those key players are executors, trustees, guardians, agents under our power of attorney and our living wills. You always need to think of 2 people to fill these roles for you because it's really important. Your estate plan could fail because you're missing those primary people. What if I named someone as my power of attorney and then the day finally comes when I'm unable to make those decisions because I'm older, I made this power of attorney when I was in my 30s, I never updated it, now I have dementia and the person I've named, they've passed away. My document is useless. I can't use it. It has no value to me. Now my family might have to go get a guardianship because no one else can act. But if there was a backup person that they could help me, they could step in that person's shoes and say, oh, the first person's not available, but I am. And then we'd have no issue. So it's important always to make sure that you have a backup to these roles. It gives you a lot of flexibility to when the unexpected happens. So it's important to have that. But also for beneficiaries, making sure that we have alternate beneficiaries, because again, just like our agents pass away, sometimes our beneficiaries die before us too. So we always need to think through that. If I want to leave my money to my son and he dies before me, then what? Then where does this money go? Maybe I don't want his wife to get it because I don't like her. Maybe I want to give it to a charity then. So that's always something that you have to think through is if that person's not available, who's the next person that I'd want to give my money to or have this person make my decisions for me? You always want to consider your alternative. We'll go on to number 6. Mistake number 6, failing to update your beneficiary designation forms. So a lot of people may not know what a beneficiary designation form is, and there are probably a lot of assets that you have that actually have this feature as part of it. A beneficiary designation form is just a form where you can name someone that you want your bank account or retirement account, whatever it is, to pass to after you die. And these are really good features, really good things to take advantage of. And a lot of things have it. So, like I mentioned, retirement accounts, life insurance, annuities have these. A lot of bank accounts, like checking and savings accounts, they also may have this ability on it. But what's important to know is that a beneficiary designation form actually overrides anything that your will says, because these beneficiary designation forms would make whatever that asset is pass by what we would call as a matter of law. So it doesn't matter that your will may say, I give my bank account to my daughter. If the beneficiary designation form on the account says I give it to my son, that's who's going to get it. So it's always important to make sure, just when you're reviewing your estate plan, you're also getting copies of these beneficiary designation forms, and you're checking those twice too, and to make sure that everything matches your plan. The other reason it's important to check these forms every once in a while is because banks get bought and sold all the time. Any insurance companies, all these financial institutions, they change hands. Documents get lost. Things get deleted. That's why it's important to always check these forms, because if you are married and then divorced and you leave your ex-wife on your retirement account, when you pass away, guess who is going to get it? Ex-wife, if that's what the document says. There's no one doing that. So it's important to make sure that these documents are accurate and they are reviewed and they are updated. So if you get divorced, if you have a kid, any of those big life changes, just like you're supposed to get your estate planning documents out and take a look at them, you got to take your beneficiary designation forms out at the same time and make sure they're accurate. So mistake number 7, this is a big one, especially now as the baby boomers are retiring, they're getting older, people are aging, but we're living longer, and living longer costs more. It costs a lot more. Nursing home costs can be about $100,000 a year. And that could destroy any estate and financial plan that you may have. You've worked all your life to save money, to buy your house, to afford the lifestyle that you have. And now you need care for yourself, whether it's in your house, whether it's in a nursing home, it could be gone within a matter of a few years, because care is so expensive. And what do we do about that? You put together your estate plan to help protect your assets and shield them, so then you can apply for Medicaid one day and not have to spend all your assets down. So when you plan to fail for this, you ultimately get cornered into a Medicaid spend down. But a Medicaid spend down is totally avoidable if you pre-plan. So if you are, Medicaid planning can be very complicated. And I will do we're doing actually a Medicaid webinar next week. So if you haven't signed up for it, go on our website. It's next Thursday at the same time. We're going to be talking about Medicaid in New York. So if you're a client in New York and you want to talk about long-term care, there's a lot of big changes coming April 1st. So please register for that webinar. If you're a client in Virginia or anywhere else, Medicaid is very different. So I handle cases in Virginia and New York. So if you want to talk about Virginia Medicaid, we can have a chat offline. But basically, if you are a client in New York and you're on the verge of needing care, then it's in your best interest to start doing some crisis planning and get it done before April 1st to get in before the rules change. Because I don't believe that there's any reason why anyone should have to work their entire life and then have to give it all away to get care for themselves. So it's important that you do the proper planning so that way when the time comes, your assets are protected and you can apply for Medicaid benefits. And as a side note, if someone wants to give money to their children, because I think that's something that we hear all the time, that someone's going to give their money to their children so they will shield their assets. I'm going to say right now for the record, don't do that. That can be very, very risky. And I'll talk more about that next week as to why that is. But I get that all the time. Like, why can't I just give my house to my kid? Or why can't I just give all my money to my daughter? Probably not a good idea, but we'll talk about that more next week. I think we have a question in the chat. Someone just answered, when is the right time to plan for long-term care? So that's always like a moving target. Right now, I would say if you're in New York and you need care now or you're on the verge of needing care, then apply now. Estate plans can be very flexible in that you can put them together at a time when you're well. And if you see that, hey, I have some health conditions, my health is declining, I'm not sure if I'm going to make it through a 5-year look back for the nursing home or a 30-month look back for community care in New York, then when you see a decline in your health or something's happening, then that's probably the time to pick up the phone and schedule a meeting with me so we could say, hey, what are the changes that we need to make for your plan? So there's not always a definite answer to say at age 60 you need to do it. It's really depending on what is going on in your life. All right, so that was mistake number 7. Now we're going to go on to mistake number 8. We're actually like really flying through this, so there'll be plenty of time for questions. Mistake number 8 is failing to fund your trust. So not everyone has a trust in their estate plan, and that's totally fine. Again, your estate plan is not something that's at all a cookie cutter. Trusts are awesome things to use in your estate plan. They're so flexible. They can be used for so many different things. I'm sure a lot of you have heard about Medicaid trusts. We use them for Medicaid planning, but we use them for 100 other things. They're really awesome to have. But if you have one and you don't fund it, it's basically useless. You got to put your assets in it. That means if you wanted to put your trust in your house in your trust, that means we have to deed the house into the trust. If you want to put cash in the trust, your bank account, you got to go set up a bank account in the name of the trust name. You want your life insurance money to go in there after you pass away, you got to update your beneficiary designation form. We do so much work with clients and get all these documents done, and then they don't fund it. It's almost useless because then it has unintended consequences. So if you leave something outside your trust, it's probably not going to end up going to the person you want it to go to. So it's really important to make sure that you fund it, because then it's going to be subject to probate. And if anyone's ever gone through a probate, it takes a really long time. Sometimes it can be very costly. There could be, if someone wants to contest a will, they can do that in a probate. It becomes a bigger challenge than you ever intended it to be, because the point of a trust is to circumvent probate, circumvent all of these other issues that were never supposed to happen, except you never funded your trust, and now we're back at square one where you didn't want to be in the first place. So again, if you have a trust, pull out your trust. I'm sure at the end of it, there's a schedule of assets that are in your trust. If you look at your trust and it's blank, you probably got some work to do. You probably got to get your assets in there. And it's probably time to just look at your estate plan as a whole and make sure, is this updated? Is this the way that I had originally designed it to be? Are there any changes I need to make? So make sure you look at your trust. Mistake number 9, leaving out your digital assets. This is a huge one, and it's an even bigger thing right now because especially in COVID, we live so much more of our lives online. Many of our assets can only be accessed online. We have Etsy accounts and we're Amazon sellers and we write books on Wattpad and we have Bitcoin and our social media accounts. So much of our lives are lived online. And we need to make sure that if we were unable to get to those accounts on our own because we're sick, we are passed away, that our loved ones can access these accounts because sometimes we have money tied up in these accounts. We need to get it out. But a standard estate plan is not going to just give anyone access to these accounts because of privacy laws that are out there today. It's really hard to get access. So a lot of times what happens is if your estate planning documents don't have specific language in them, we need to go to court and get a court order to get access to your cell phone, to get access to your online bank account, whatever it may be. And that can become a problem because what happens if you are in the hospital sick and we can't get into your phone to get into your email to pay your mortgage? Or just to get access to funds to make sure that we have care for you when you come home out of the hospital. It's important that people have the access to these accounts, trusted people, not just anyone. Your trusted individuals in your circle should know what to do in the case of an emergency. And one of the things people need to know is how to access your digital assets. So one thing I recommend is to make sure that you have an updated list of accounts and usernames. And I'm not talking about everything. I don't need to know what your username and your password to your Gap account is online to go shopping, but your bank accounts, maybe your social media. If you are an online seller, to your Etsy shop, maybe if you keep your sensitive documents on something like a cloud sharing, like Google Drive, OneDrive, if that's where all your information is that someone needs to get to, then yeah, make sure that someone knows how to get into that so they can help you at a time when you need it. Because again, like I said, a good estate plan is going to be able to help you gain access to this information instead of having to waste time and money to get a court order to get into your online accounts. And I know it's very tedious to keep an updated list of accounts, but you don't know how big of a help it is on the other end of this when we actually do need to use it and get into your accounts. The last mistake is failing to communicate. And this is probably the hardest part for so many people. So I'll say this, I'm very honored and privileged to be able to work with so many families and help put together a plan that, to see through after they pass away. But the hardest part is getting everyone to communicate what they want to their family, like to actually sit down and have a family meeting. It's so difficult for some people because family dynamics can be very difficult. It can be very hard to have a conversation about what you want for yourself at the end of your life or how you want your assets passed along after you pass away. These are hard conversations, but these meetings are so essential to the estate plan, because it's important to share with your loved ones exactly what you want for yourself. You need to be able to give an overview of the plan that you have for yourself and why you've chosen certain decisions. I actually just posted a blog article on this, so if you want like more information, you can go to our website and find it. But communication is always important, and it's especially important when discussing your estate plan. A failure to communicate can cause hurt feelings. Sometimes people feel like, why did mom or dad tell this person the important information and not me? And that's not something, that's probably not a feeling that I would want one of my family members to take away after I pass away. I wouldn't want them feeling left out. And a lot of times when that happens, that's when the fighting starts. And that's when the will contests start or the fights over the money start. And then when the wheels start to fall off, your estate plan doesn't really go the way that you plan for. So family meetings are essential. It will help you avoid a lot of associated costs when you talk about fighting wills, fighting other family members, fighting over money. That costs a lot of money to do that, and it could probably be solved with a family meeting. So that's the first piece to the communication, failing to communicate. The other part is you have to let people know where your estate planning documents are. You know, if you hide it in your house or you have it locked up in a safe that no one can get to, that's a problem because then the documents are useless and you kind of have this whole plan and now no one can use it. So it's important to let your family know where everything is. You know, how can they access this? Everything needs to be stored in a safe place. It should be waterproof and fireproof, but it shouldn't be where no one else can access it. So if you have it in a safe at home, someone needs to know how to access that. If you have it in a safe deposit box in a bank, it's important that someone else that you trust can get access to that box. Safe deposit box are very hard to get access to after you've passed away. And I almost, depending on what you want to put in a safe deposit box, you should really be cautious about what you put in there. It might not be a great idea to put your estate planning documents or your valuables in there. I think I have the impression that safe deposit boxes are being phased out. There are a lot of work for banks to deal with. I know a lot of new branches are being built and they're not including safe deposit boxes. So the number of safe deposit boxes available are dwindling. When banks sell and change hands, they have to move your stuff to another branch, or when that branch closes, they actually have to move your stuff somewhere else to another branch. And that doesn't give me a comfortable feeling knowing that someone else could potentially be handling my estate plan, my valuables, because how do I know that it's not going to get lost or mishandled? So I would urge you to consider if a safe deposit box is the right thing for you, and if it is, make sure that you have a signer on the account, someone else that can get access to it. But it's important that people know where these important documents are. Now, I will say that when you have your estate plan put together, you never want to have to give originals to someone. So if you need to make copies and give a copy to your bank or your doctor or a kid or someone that you trust, that's fine. But the originals need to be stored in a safe place. So now these are the common mistakes that we see. There's a ton of other mistakes that happen along the way that we see too, but these are the most common mistakes and they're totally avoidable. The solutions are pretty simple. First one is making your estate plan a priority. It's an obvious solution to go out and either create your estate plan or pull out your old one and review it and get it updated. This is the simple answer. Now, when I say go out and make an estate plan and update it, I don't mean run to LegalZoom. I don't mean go online and find a do-it-yourself service and get a promo code and get it for the cheapest amount possible. I am going to caution you that online do-it-yourself estate planning programs are very popular and they're very cost effective for many people, but you have to use it very cautiously because it doesn't take most anything into consideration. A lot of what we're talking about tonight, all these special considerations that you need to put in your estate plan, none of that is in the equation for an online do-it-yourself will program. So it is important to find an attorney that knows and is familiar with estate planning. There's so many ins and outs with gifting laws, tax considerations. There's so many intricacies to this. It's important to find an attorney that this is their area of practice, and they can guide you through the process, and you'll have a plan that really will give you peace of mind, and know that it won't create other issues down the line, like so many do-it-yourself wills that come into our office. So make this a priority and get with someone that that knows what they're doing. Now, I will totally put a plug for our firm here to say that we know what we're doing. Like I said, this is all I do is estate planning and elder law. So I do consultations. You're actually going to get an email tomorrow with a link to my calendar. You'll have access to my calendar to see my availability. If you want to schedule a consultation, I give free consultations. We can totally sit down, talk about what you're looking to do, and I'll share some recommendations with you. So that's the first solution. The second solution is educating yourself. Estate planning is probably one of the most important things that you could do for yourselves and your loved ones. It provides a form of protection and peace of mind. You can protect yourself, protect your beneficiaries and your loved ones, and you can avoid messes. And it's important to know that, you know, based on the type of care that you want for yourself and the type of assets that you have, educate on how do you go about making those things known to your loved ones. I can go on and on about why estate planning is so crucial, so essential. I'm very passionate about what I do. I believe that everyone needs an estate plan. So it's important to educate yourself. And as I mentioned, the consultations, I do free consultations. It's important, you know, that anyone that you consult with, any attorney, make sure that they specialize in this area. There's so many layers of complications. Laws are constantly changing when it comes to matters related to aging and trust in estates. It's really hard to keep up with it. So if you have an attorney that specializes in this area, they almost always have their ear to the ground and know what's going on. And that makes them the best people to help you and your family when you need an estate plan. So that's all that I have for tonight. I'm going to before I open the floor up to questions, here's how you can get in contact with us. You can find us on social media. We're on Facebook. We're also on LinkedIn. You can email us. Like I said, if you want the slides from tonight, you can send an email to info@monteleonelaw.com, and I'll shoot you an email right back with the slides. If you want, you can give us a call. Or you can go on our website. We are building our resources on our website. So we'll have this webinar posted there. We have a few other webinars posted. We have our blog on there. And there's some other resources that will be coming out throughout the year that will help you educate yourself. So does anyone have any questions? Feel free to put it in the chat. And I don't know if you guys can raise your hand. I guess I'm not sure, but if you want to put a question in the chat, I will totally answer you right now. And if not, if you have something that you want to talk about offline, feel free to shoot us an email, give us a call. I'm like really responsive. So I'd be happy to discuss anything offline. And I'll just leave the floor open for a couple minutes for anyone to put a question forward. Someone just asked a question about what if you want to make a change after your will is drafted? And that's a really good question. So that's where the review process comes in. So if there's a change in your will that you want to make, depending on what the change is, we either redraft and execute a new will, or you could do what's called a codicil, and that's just like an amendment to your will. So you can do that. Or if you have a trust and you'd like to change it, if you can, and if you can make a revision to the trust, you would just amend it and sign off on the amendments, and then it's changed. So it's not as complicated as actually drafting your initial estate plan, or it's not always that complicated. All right, well, if there's no other questions, then I'm going to end our presentation here. Thank you so much for joining us tonight. Like I said, we have 5 more sessions happening every Thursday evening for the next 5 weeks. Next week's session is on the Medicaid changes in New York State. We have other sessions about caring for caregivers, long-term care insurance, policy essentials, retirement planning, what to do when someone dies. And there's one more, I just can't remember it right now, but everything is on our website, monteleonelaw.com. Just go to the resources tab and you'll find the webinar information. And I hope to see you guys at our next webinar. Thanks so much for joining.